Hello, everybody. Hello, everybody. Welcome to the live. Welcome to the live. Thank you for tuning in. Hello to the playback crew. We'll see how many people we can get in here in the first few minutes because we've got some motions to discuss and a little bit of news. There was a filing today from the prosecutors responding to Brian Steele's motion asking the judge to reconsider her rule. Judge Krause's ruling on the ex parte, so we can get into that. But we've got Doug Weinstein here, who some of you know from previous interviews. He represents Deamonte Kendrick, who is Yak Gotti, the rapper signed to the Young Stoner Life label with Young Thug. And he's here to discuss some of the new motions with us and his reactions, including the request for a gag order, which we talked about yesterday. Prosecutors have filed that, complaining about some of the interviews that they've done with Sylvia and the account I'm Not a Lawyer, and then yours truly. So, Doug, thank you so much for joining us this afternoon. I did see your response on Twitter a few minutes ago where, you said that you have a duty to represent your client who's a public figure and that he's been smeared by prosecutors. And is that, can we expect to see an argument like that in a filing that responds to this gag order request? Is that the defense here?
Yeah, and just to be clear, I don't think I used the word smeared by the prosecutors, but I think I said that his reputation has been tarnished by the state. I don't know if that makes a huge difference, but first off, I should start by telling ADA Love and Hilton hello. How are you guys doing? So I guess y'all are watching me now, and maybe have always been. So how are we going to respond? Well, it's pretty simple. Just look at the rule that the state cited in their motion, Rule 3.6. And I'm permitted under that to comment on information that is in the public domain. And so my comments have been limited to those things that have been filed publicly, that have taken place in the courtroom. It's unlike, maybe not as the state wishes, but this is a public trial. The witnesses, all the proceedings have been streamed out to the public. The courtroom has been open. I know that the state has repeatedly wished that some of the witnesses not be put on video. And for the most part, they've gotten their way on that. But I think this is just part of the pattern of the state not wanting the public to see what's happening in there. And yeah, I have the absolute right and obligation to speak out. My client's a public figure. He has a career as a singer, as an artist, as a writer. And I have a duty to him to not only advocate for him in the classroom, but to advocate for him in the public arena.
And it seems like their reading of the Georgia Rules of Professional Conduct. I mean, when I'm reading this, I'm like, does their interpretation of this allow for any public comment whatsoever? The comments that they cited seem to be criticisms of them and then proclamations from the defense that their clients are innocent. But that seems to be stuff that we hear about in cases, in high-profile cases.
Yeah, and we're absolutely under Rule 3.6 allowed to do that. And it wouldn't be the first time that they have put forth an argument that I believe doesn't have merit. So I'm happy to file a response and swat this away. But unless, of course, I'll do whatever the court orders. Let me make that clear.
Yeah.
But I don't believe that a court, this court, or any court would rule in their favor on this or will rule in their favor. So I don't anticipate being gagged in any way by this judge. I mean, I was looking back in Georgia, like there was a gag order in the Ahmaud Arbery case, but that was a very different situation, if you remember, Meghann. I mean, did you look at that gag order?
No, I haven't seen the gag order. I'm familiar with the basics of that case, but what do you see as the big differences that led to the gag order there?
Sure. In that case, that was an order that took place before the trial commenced. So you had obviously potential jurors that were out there that could be seeing the statements. And in this case, our jury is impaneled. And they are under a directive from the judge to not consume any information about this case, to not talk about this case. And Chief Judge Glanville always did a great job at the end of, I think, every day, giving the jury, and you guys have seen it, he gives the jury the directives on what they're allowed to do, what they're not allowed to do. And so we have to presume that the jurors are following the instructions of the judge. So they shouldn't be consuming any of this in any way. So I don't think any statements I make are prejudicing this trial at all. All I'm doing is educating the public on what's happening in that courtroom.
Right. Right. I did see just through a quick Google search that there was a gag order issued in the RICO case involving the Cop City protesters. Is that do you see differences between that case and this case, or just what they're doing? Or were they weren't like 19 months into trial when that gag order was issued?
Yeah, and I haven't seen that gag order. I mean, obviously, I'm Suri Chada Jimenez is a colleague of mine, and I believe he's under that gag order. And I haven't been following Cop City that much, but I do know they haven't gone to trial yet. So I haven't read the order, but that's a major difference, because that's a situation, again, like Ahmaud Arbery, where you've got potential jurors that would be out there consuming media. Our jurors are not doing that. They're instructed not to do that. They've been impaneled. No, they're not sequestered, but they are under instructions to not look at any of this.
And it seems like if it, for some reason, the jurors did see those statements, we have a much bigger problem in our hands than just the defense attorneys need to stop talking. It would mean that jurors were in violation of this order, correct? I mean, there's some argument that a gag order like this in the middle of trial kind of undermines the integrity of the jury, because it almost kind of assumes or worries that the jury is violating their oath not to look at this stuff.
Well, I would just say it's unnecessary at this point for there to be a gag order, given the orders that the jury is under. And our jurors seem to be very conscientious. You know, I know that in whenever I filed the order to try to get this trial moving, filed the motion, I wish it would have been an order, in late March or early April to try to get this trial moving along and to eliminate redundant witnesses. I was concerned that the jury would lose focus as this trial dragged on. And I cited a bunch of studies in that motion to the judge, showing that jurors kind of lose focus after 10 or 20 days of trial. And of course, we're past day 100. But when I look at them over there, for the most part, they're paying attention, they're taking notes. So I think that they would be following the judge's admonitions. I think that's what Judge Glanville would always call them, his admonitions.
Yes. Yeah. And one, I mean, just in my experience, I've had attorneys tell me that, they think all jurors violate that. But a clerk I know who worked in state courts for a number of years and then federal courts, and she's the one who actually deals with the jury every day, talks to them. She thinks they actually take that pretty seriously, and that if one of them does violate it and the other people find out, they all kind of rat each other out. But then another way to look at it is, if you were sitting all day in a jury in a case like that, would you want to go spend your time off reading more about the case and thinking more about the case? Maybe you don't.
Yeah, in my experience, I think they would be eager to get home and think about anything else than what they've had to watch for the last day.
How saturated is the news, though? I mean, just being in California, we don't see it on the local news, but it's on the local news every night in Atlanta, right? Just a trial update, and then especially more coverage in the last few weeks.
Yeah, it's interesting, and I'm not a big consumer of local news. I read the AJC. I don't really watch much, but just from reporters reaching out to me, for a time, there was a lot of interest when the case began, opening arguments, and then with certain witnesses, there's more interest. I think with Kenneth Copeland, there was more interest, but the media kind of went away for a while. But yeah, they're back again. So with all the motions with Judge Glanville being recused, it's in the news a lot. So I think for a juror, I imagine the jurors are probably just avoiding any kind of local news consumption. I think it's the only way to really avoid this.
Yeah. So with 6 defense attorneys, how do you decide who's going to respond to the prosecution motions? I know of 2, the gag order request and then also the request regarding supposed character evidence regarding Donovan Thomas. Is that, how do you folks decide? Are you all going to file a response to the gag order request, or is it just one?
That's a great question. I have not discussed that with the other defense attorneys. I mean, I was singled out in it, so I'm certainly going to be filing a response to that. I would imagine the others that were singled out will be filing a response, but honestly, I haven't talked to them about that.
Yeah, yeah. And so yesterday you filed the motion for mistrial and also a bail request for Deamonte Kendrick? Are
That's
those
correct.
your 2 motions you have pending right now?
That's right.
And the mistrial is along with some other mistrial requests, but it specifically says makes the double jeopardy argument, correct? And that's important for people watching at home. A double jeopardy finding would mean that they can't be retried again. So that's your ultimate hope, right?
My ultimate hope. Although in this motion, I'm more laying the groundwork for factual findings that would support a later argument for double jeopardy. I'm not specifically requesting the court to find mistrial and effectively a plea in bar, as we would call it in Georgia, to bar further another trial of double jeopardy. Kind of taking everything a step at a time. So yeah. We got the mistrial. I'm sorry, we got the recusal, which was warranted based on those things I mentioned in my motion for mistrial. I'm hoping that we get a mistrial. And I believe that really the basis for the mistrial should be our being goaded into it. I think and I say this, of course, I repeat it in the motion over and over again. It's a bit of a theme, I think. But we're winning the case right now. I think Max Sharp has said the same thing. We're winning, and he says it very explicitly in his motion. I think mine was more like the state is losing, and they've goaded us into a mistrial so they can restart. I think Max just came right out and said we're winning, and I do think we're winning.
Right, because Max's motion it's a motion for fair and constitutional trial, much like Brian Steele filed a few weeks ago, and I think that's still technically pending, right? But he makes the argument that starting over really isn't in Shannon Stillwell's best interest. And so, I mean, he doesn't want a mistrial unless there's a double jeopardy finding. Is that one advantage of having so many defense attorneys working on a case? He can feel comfortable making that motion himself because there are other mistrial motions pending. So if there is a mistrial with double jeopardy, it'll attach to him too.
I think one clear advantage to having multiple defendants in a case, I mean, of course, there's disadvantages too, but one clear advantage is that we can take different approaches to things. And this isn't some kind of coordinated, I mean, I wish it was that well coordinated. This isn't a coordinated, hey, we're going to take different avenues of attack. But you do have different approaches to this mistrial. So, Max's seems to be, I want a mistrial, but only if we can get it with double jeopardy attaching. And in fairness, that's probably what we should get. This case is so messed up at this point for so many different reasons. I mean, I was struggling to decide how I was going to approach this motion for mistrial because there's so many different grounds that we could look at. But just in my, I guess it's my philosophy that I try to do things in a narrower, more focused manner. I don't want to overwhelm the judge with here are 12 reasons we should have a mistrial. Yeah. And by the way, if you look at like Bruce Harvey's motion, I don't think his is that way. I don't think his is here's 9 reasons we should have a mistrial. His is more like there's no way a judge can parachute into this case and even attempt to conduct a fair trial going forward. And here are the 8 or 9 reasons why a judge can't be dropped into this case and just continue. And I agree with Bruce as well. All of these are valid reasons for a mistrial.
Yeah, I found Bruce is so persuasive, and part of it is just the situation itself for any judge, but then a lot of the Glanville's own rulings and his own statements throughout trial saying, oh, well, we can revisit that later, and he would always say that. So it seems like those statements right there kind of justify it. But I saw somebody asked, we kind of touched on this, but Antonio Lee asked if this is the strongest mistrial motion you filed. It seems like it's the one with the most going on.
I mean, I think this is the strongest. This is the most egregious violation of a defendant's rights I've seen. So in that sense, I would say it's the strongest mistrial motion. They're just those three reasons that I cite in the motion, I think are any one of them would be more than sufficient to grant us a mistrial.
And then Jeffrey asked if the mistrial, when the mistrial gets denied, does it get immediately appealed and stay the proceeding, or would that involve Judge Whitaker actually issuing a stay? Would she have to issue a stay so you can appeal it?
Yeah, I don't believe that it would immediately trigger a stay and an appeal. I believe that we would need a certificate of immediate review. And then she would have to order some type of a stay of the case. I think. Don't hold me to that. But you know, we plan on winning this. But I think I need a certificate of immediate review if she denies it. And I don't know if she would grant that certificate.
Yeah, it's going to be. I mean, she seemed to really be taking a full steam ahead approach at the last meeting. I mean, when I was reading Bruce Harvey's motion, I was like, I'm completely persuaded that there should be a mistrial. But I do just remind yourself that she knew all this going into the status conference, and she took that kind of let's go forward attitude. And I mean, Bruce even quotes her in there saying that she's not going to go back and review all that stuff. It's like, okay, well, how can you make informed decisions going forward? But
well, think about it. How can she review it? She doesn't have a transcript to review.
Yeah,
I mean, there's over 100 days of testimony. There's all of these rulings, but even the 100 days of testimony, you go back and watch the YouTube videos. It's not practical. Yeah, I thought Bruce's motion was terribly persuasive.
Yeah. And somebody points out, and I think, sorry. I think we just lost Doug here. Hopefully, there we go. Hopefully, there we go. Somebody asked, I think Thugger Daily posted this. The Adrian Love pointing out the recusal that Judge Whitaker had recused herself like 6 years ago from a case involving Young Thug's brother, because when she was in the DA's office, she worked on an appeal involving that case. And it sounds like the prosecutors were basically just pointing this out. They weren't asking for any action on it. Is that what's the reason for that? Does the defense have any kind of response to that? Or they?
I don't know, because I haven't gotten to research that issue, so I can't really speak intelligently to it yet. I don't know where they're going with that.
Yeah, I mean, you could almost take it as, is that some kind of warning to Judge Whitaker? But it seems like if they wanted her to get off the case and thought they had a case for recusal, they would just ask to get her recused. So
yeah, I would think that if they believed that merited recusal, that they would have a duty to file that motion and seek that recusal.
Yeah, and then this question gets into really a pretty big motion from Brian Steele, and you touched on this in your mistrial motion too, that Judge Krause ruled that she said she generally agreed with Judge Glanville's assessment of the ex parte, and really her reason for recusing Judge Glanville had nothing to do with that. It was all about how he defended himself against these recusal motions. So one motion that Judge Whitaker needs to decide from Young Thug's lawyer, Brian Steele, is he wants Judge Whitaker to take back those findings from Judge Krause and say that the ex parte was illegal. Did you ask for that up front in your mistrial motion, or is it the mistrial motion kind of depends on that, right?
I don't want to say it depends on it, because I gave 3 bases for the mistrial. And so I would say perhaps one of those bases depends on the judge seeing the ex parte, just the holding of the ex parte meeting as improper. But I also say that the conduct of the judge in the course of the ex parte proceeding was not proper. And I believe maybe Judge Krause in her ruling would not have agreed with that. So I do need that to be altered. And it's implicit, I think, in the motion. that I filed, and it'll have to be made explicit when I argue it. But
Yeah.
also, if you put everything having to do with the ex parte proceeding aside, I mean, just set it aside. The third grounds I had was that Chief Judge Glanville didn't follow Rule 25. And after I filed my motion for recusal on June the 12th, he didn't stop all proceedings and refer it out. So we heard another 3.5 days of testimony from Copeland. And according to Georgia law, all of that is void. And so another basis for my mistrial is the inability to unring that bell, for the jury to unhear that testimony.
Is there any chance that, is the judge going to come out next week and try to argue that what's the big deal with Woody's testimony? Like, could you envision that being any kind of legal argument against this? Because everything that I've read and everything I've heard seems it's pretty cut and dry that this does need to be rewound, that some of it is going to be invalid. So is there any chance the judge could try to argue that it doesn't? I mean, is there any history of that?
I mean, the case, I think anyone that argues against this would be going against the case law, because the case law in Georgia is pretty cut and dry, that everything after that, all the formalities of seeking recusal were met, which was June 12th. And the judge, it had to be stopped then.
Yeah.
So I don't know how you say, maybe you say, well, I don't want to work on their side. I mean, do you say harmless error? But
yeah. It's a pretty big witness.
It's the witness. It's the witness against my client. He is the witness.
Yeah.
And that's why I think it was so disturbing that this happened, that the ex parte meeting happened, that we were not permitted to participate, that the judge coerced, and it's clear. I mean, read the transcript. Mm-hmm. The judge coerced Copeland into changing his mind. And there's plenty of case law in Georgia that says a judge cannot do that. I've got that Webb case from the Supreme Court and its lineage that says it's a little bit reversed. It says that a judge cannot intimidate a defense witness into not testifying. But if you get into the logic of that, that's not dissimilar from a judge coercing a prosecution witness to testify. Or at least I think so. So anyway, I think even if Judge Whitaker does not find the ex parte to be improper, I think the coercion and then the continuing with the trial was improper. And again, everything I'm telling you is in the pleadings.
Yeah. Yeah. What about, I know there are a lot of questions about what's currently going on with Woody. I mean, he's been embracing his social media stardom and creating accounts, doing interviews. He's available for bookings. I mean, as a journalist, I've just kind of ignored it because I don't see it as being directly relevant to the case. And I mean, there's no gag order on him. I mean, it seems like he's free to do whatever he wants, but can we expect this to come up in trial? Is it going to be an issue that he's talking to people?
Well, I think it's relevant to me in the sense that the state has been painting our clients as intimidating witnesses repeatedly. The questions they're asking them in front of the jury, basically they are implying that the witnesses' stories are changing. The reason the state has to consistently impeach their own witnesses is because some type of intimidation by our clients. The witnesses are afraid of us. I don't think Mr. Copeland looks afraid of us. Does he look afraid that, he's live Instagramming his whereabouts? Yeah. I don't think he's afraid somebody's going to come after him.
No, I mean,
or at least not us. He seems more concerned about the state locking him up.
So it seems like if we're going to be hearing about Woody's, newfound public persona, it's more likely to come in the cross-examination because, like you said, it lends into this, are you really being intimidated? I mean, it'll be interesting to see if the prosecutors bring it up because when you kind of put it that way, it's like, does it really benefit their case to let the jury know that, Woody now has 300,000 followers on TikTok or whatever it is?
Yeah, I mean, there's a lot of complicated issues we're going to have to deal with going forward. We're going to have to explain to the jury what happened to the judge.
Yes. And how, I mean, just when I was looking at, changing judges midstream, California has a policy that says if a judge, as Brian Steele would say, God forbid, if a judge dies or has a health problem in the middle of the proceeding, it's like a written policy about how this can continue. A judge can take over the trial. But when you read this policy from 1997, they were thinking about misdemeanor cases, DUI cases, not some 19-month complex RICO trial, right? Does Georgia have a policy like that regarding health problems with judges?
I don't believe so. This whole situation is, in some sense, sui generis, right? It's unusual. If you look at everything about, for example, recusal, it's not, because trials are usually a few days, a week, maybe 2 weeks.
Yeah.
It's not anticipated that a judge will be recused in the midst of trial. It does happen at times around the country. I was searching everywhere for cases. I found some up in Chicago. It's just very unusual. They usually result in a mistrial. Actually, I haven't found one where they haven't resulted in a mistrial. And sometimes they result in double jeopardy. It depends on, sometimes double jeopardy attack. It depends on the reason for the recusal. But I think the best policy is to tell the jury the truth.
Yeah. Would that be, and to just say that the judge was recused from the case? Or, it seems like in all the cases that I've covered, they would want to just say, there's been a change with the judge. You're not supposed to read anything to it one way or the other against the defense or the prosecutors.
Yeah, I haven't fully formulated my my ideas on that yet about how exactly we should approach that with the jury. I know that we should be truthful, and the degree of information we relay to them, I'm still thinking about.
Yeah.
At least my position. It's ultimately up to the judge, but
yeah.
Because here's the thing, Judge Glanville's a witness in this case.
Yes.
He's been named by Brian Steele as a witness. ADA Hilton's a witness. ADA Love is a witness. That's going to have to be explained to the jury.
And that gets into their motion. There's still a pending motion from Brian Steele to recuse DA Hilton and DA Love, right? That's currently pending. We can expect a response from the prosecutors on Friday, I think.
That's what the judge has ordered. If I heard the judge properly, and I think I did, the judge said all motions must have been filed by yesterday, and all responses are due this Friday. So I would have expected the state to put all their motions in yesterday, if you're going to follow the judge's orders, and then our responses are due Friday. So their responses are due Friday, our responses are due Friday.
And then it's Tuesday morning that this all starts. And I know you can't make any predictions, but I was thinking, I'm so interested in this right now that for a long time, I felt like this trial, while it's so important and fun, fun might not be the right word, but the testimony was really engaging, like Trontavious Stevens. Legally, it felt like kind of a dud of a case because it wasn't a real RICO case. The prosecutors were in way over their head. Glanville was in way over his head. But this unprecedented judge recusal and the moving in of a new judge in the middle of trial has given it this whole legal intrigue now that I think is really interesting, could really interest people in the legal community, down to what's the first motion that the judge is going to deal with on Tuesday? Does she deal with the mistrial motions first, or what would your preference be?
I don't know about preference, but I'll talk about what I think is legal reality or practicality. I don't see how you don't address Brian Steele's recusal of the prosecutors right off the bat, because if that is warranted, shouldn't it be done before they start arguing these other motions? That's how I would look at it,
because that would basically end it right there.
And I'm not speaking. I don't want to speak for Brian. I don't know what his position is, but just looking at it, I'm dying to get in and argue my mistrial. I'd love to Tuesday morning just go into it, but it seems to me as a threshold matter, you have to decide whether these prosecutors can continue in their role in this case.
So ideally, the order, would the first motion to build a foundation for that, would it be best to hear the motion to rescind Judge Krause's finding about the propriety of the ex parte ruling? Because if for some reason Judge Whitaker is willing to say that that ex parte was improper, that lays the foundation to get rid of the prosecutors, right?
Yeah, I mean, I guess that's a great question. I don't know. I think you could do the prosecutors first, and then you could get, because I think what I don't know.
Well, because the argument is even without a finding that that ex parte was improper, that doesn't change the argument that there's still witnesses in the case, right?
That's right. That's right.
Okay, and that's the recusal for them.
Because this gets into the credibility of Mr. Copeland. It gets into a lot of issues. I think it's important that the prosecutors get up there and that Brian examine them on, what they did in that meeting. And again, it's not necessarily about the meeting. It goes to the credibility of Copeland when he's on the stand and what he's testifying to after he's been, bullied into testifying.
Yeah.
Because this is a man that he has admitted on the stand repeatedly that he lies. He lies to avoid going to jail. He seems to be, I just look at his words. I don't need to repeat his words.
Yeah.
And he seems to testify that, these are my words and not his, but he seems to sprinkle grains of truth in the stories he makes up to law enforcement to give them credibility. Yeah.
And it seems like for people who are catching up, we're going over the motions that were filed. They're going to be dealt with on next Tuesday. The big one that got a lot of attention is a request for a gag order. But I was saying yesterday that one that seems really substantive, and it's the first test of whether Judge Whitaker is willing to change rulings that Judge Glanville made, is the one regarding the hearsay statements of Garlington that they want to ask Copeland about. And for people catching up, the 2015 interview with Kenneth Copeland, one of his 2015 interviews, he said that Shannon Stillwell and Deamonte Garlington got into a car with him after Donovan Thomas's murder and basically confessed that little D said something that was akin to a confession. But as we all know, Woody has not backed up anything he said on the stand. So now prosecutors want to bring in that statement from him and ask him about it. But there was a whole debate about it being hearsay and not admissible. And now it sounds like there's a hope from the defense that they can get that ruling changed and prosecutors won't be able to bring it up. Did I?
Yeah, I think you've summed that up nicely. I mean, the big issue is that these statements were admitted by Judge Glanville as statements of a co-conspirator. But if you look at that hearsay exception, those statements have to be in furtherance of the conspiracy.
Yes.
And that language appeared to be read out by the judge when he was making his rulings, or ignored, to me at least. Of course, I'm biased, but he didn't seem to pay attention to that aspect of the hearsay exception. And there's clear case law in Georgia that mere spilling the beans, telling people someone after the fact, that's not a statement of co-conspirator that can come in. That doesn't work under the hearsay exception. So there's a lot of rulings that I'm sure both sides would like to revisit. I think this judge is reluctant to revisit some of those, but I think when you've got, when you have clear error, what I think is clear error, how can the judge ignore that going forward?
And especially with this ruling, while this ruling was made, it hasn't been implemented yet, right? We have not, the jury hasn't come back, and Copeland, these statements haven't been played for Copeland. So there's definitely room for her to change. That's true.
Okay. There's still time to fix this.
Okay.
If the case proceeds.
It looks like somebody was Tasha Kendrick. Is this Deamonte's mother or his?
This is Deamonte's mother. Hi, Tasha. Tasha, who's in the courtroom pretty much every day. She's an amazing supporter of her son.
That's great.
And I really, because but Tasha does a lot of working at night and then coming into court all day. So I don't know how she's even functional, but she's fantastic.
That's awesome. And I think that's one forgotten aspect of the case, because and just watching it on the live stream, we don't really even see the gallery very much at all. But yeah, I mean, these people have family members that want to see them and want to follow the case, and just the exhaustion of having to go to the courthouse every day, it just must be totally different. But
well, it's massive stress. It's massive stress because
yeah.
you're not only exhausted because you're working at night or evenings and then going to court during the day, but your son is on trial.
Yeah, yeah, yeah. Well, is there some thought that, I mean, for Mrs. Kendrick and then just for the attorneys, that there's going to be some relief that you no longer have a judge saying, let's just see where the day leads us? Yeah, it sounds like you're going to have a set end time, hopefully. I mean, it can be.
I am thrilled with the idea of starting at 8:45 sharp every morning, and going as long as if the jury's comfortable going to 6, I'm all for it. I mean, I'm the one that basically complained about this trial dragging on too long. So yes. I have to, I mean, the only reasonable position that I could have is, yes, thank God, let's move this forward. Because if this case is not going to result in a mistrial, let's get it in the hands of a jury as soon as possible and get my client out of jail.
Well, it sounds like, I mean, we were averaging maybe 2 to 2.5 hours of testimony a day, maybe 3. I mean, it seemed like with all the comfort breaks, there's a federal judge in LA that's a little crazy, but he gets like 5.5 to 5 to 6 hours of testimony in a day because he starts at 8 and he goes to 2 or 2:30 and he doesn't take a lunch and he only takes 2 10-minute breaks. And that's a little crazy, but hopefully we don't have quite like that.
Don't give Chief Judge Glanville too much grief about the number of breaks. If you want to give him some grief on the length of breaks, I won't defend that. But he was giving breaks. A lot of it was because of my medical issues that he would give me a break every once in a while. I didn't need 45 minutes, maybe 5, but I think he was doing that. I mean, also, it's just like I've told you before. It's very, very taxing in there. I don't know, but I'm fine with let's put this on speed and let's get through this. And I was really glad to hear Judge Whitaker say that when she sees a witness who is redundant, she's gonna, she has the power to eliminate that witness, which is what I requested of Judge Glanville back in April.
Yeah, because I know we talked about this before, and I'd kind of wondered out loud. I'm like, all the comfort breaks and just how obnoxious the schedule is. I was kind of wondering, does it help the defense to have the prosecution's case so jumbled like that? But you had said that you really think it really benefits both sides to have the case streamlined. But with you guys thinking you already have the advantage, having it streamlined obviously you think it has way more benefits than possible.
Yeah. Again, I mean, Deamonte Kendrick is locked up in Rice Street, one of the worst jails in the country. Probably only Rikers Island is worse. And I don't even know that for sure. I do not want him in there one day longer than he has to be. Yeah.
Period. And that brings us to the bail motions. There's bail motions pending. The arguments, of course, are the arguments made under Judge Glanville, but you feel like there's new circumstances that warrant the reconsideration from the new judge.
Certainly, because it's been I think the last time I asked for bond was, I don't know, 14 or 15 months ago now. So the situation has changed. The trial is not moved with any kind of expediency. And I think the grounds, I mean, the basis for giving him bond is still just as valid today as it was a year ago. I mean, look, when we first asked for bond, the state, 2 years ago, 2+ years ago, the state got up there and talked about how dangerous all these guys were. They were a threat, all of them, like all 28 or however many were locked up at the time. Yeah. How dangerous they all were. I mean, this is, again, public information. It's out there what they argued. And then how many of them pled out within about 6 months and are back on the street? I mean, if they're so dangerous that they couldn't get bond, then why are you releasing them on the street? So I just don't think the state has credibility. And so I know when they argued last time, they mentioned a couple of incidents in the jail, which are all crap. And I'm not representing Deamonte Kendrick in those, but I think they're all going to be resolved in his favor. Anyway, that's what they brought up. And again, that's just... Anyway, if you look at the Ayala factors, the Georgia factors for bond, I still believe that he merits bond. All these guys merit bond, but I'm not their attorneys.
So we can expect those to be dealt with next week. Like, and we can't make any predictions on what order the judge is going to take these in. But are you have you penciled out all of next week? Should we expect this to be Tuesday, Wednesday, Thursday, Friday, or?
I expect Tuesday through Friday to be fully booked with this, and I just hope we can get through all the motions next week.
Right, because she was saying the jury was scheduled to be off next week anyway, but she had said something about we'll see if we can call them back in August 5th or August 12th. But that also just seemed to be kind of the opening day, narrative for her that she's trying to push forward, because she had not dealt with any of these arguments for mistrial yet.
That's
so
right.
You're hoping that you can change your mind.
Yeah.
So.
And I think the bond motion should go after the mistrial motion, because that could affect that.
Yes. Yes.
If we get a mistrial, I just don't see any. There's zero reason he should not continue to remain in jail. He shouldn't be there anyway, but certainly not if there's a mistrial.
And that's if there's a mistrial with no double jeopardy attached, because it sounds like you'll take that mistrial anyway, but then you're hoping that really warrants the release. Whereas obviously if there was a mistrial finding with double jeopardy attached, they would all be released because there'd be no more charges anymore.
I would think so, yeah. But we have to take everything a step at a time, and that's what we'll do.
Because I'm seeing some questions in the chat about if there is a mistrial, what are the chances that they retry it? And I think the chances are pretty great, which is why you're hoping for the double jeopardy finding that would prevent.
I have to tell you, people I talk to, criminal defense lawyers in Georgia, folks that have been practicing for a long time, everyone's all over the map as to what they think the DA's office will do if there's a mistrial. Well, so I don't even begin to guess what they're going to do.
Is there an election in November? Is Fani Willis up for re-election?
There is, but she won the Democratic primary, so I don't expect. I think she's in.
Because I was wondering if the YSL trial is a political issue at all, but it sounds like there's no chance that whoever her opponent is right now isn't going to win. So
I think the Trump trial and the YSL, to some degree, maybe the YSL trial could have. I mean, it's more the Trump trial that was an issue in her primary. Yeah. But having pretty much sailed through that primary, I'm sure she's all set for re-election. Yeah.
Well, what else should people know going forward for people who are just joining? We were talking about all the motions that have been filed, and there are the basics: the mistrial and the bail motion. But the one that caught some headlines is the gag order request. But
yeah, I think the big thing is just to watch on Friday when both sides' responses drop. Because then you'll have more to talk about. But I wouldn't expect any more motions to be filed today, tomorrow, because the judge pretty clearly said they had to be filed yesterday.